I am Chris Irons from Strata Solve and briefly frozen, but now back. Frank Higginson, partner Hines Legal. Frank, welcome.
Hello, Chris. Hello, everyone.
It's always disconcerting when that happens, isn't it?
It is.
Yes. But anyway, you're there now, and that's all that matters. Thanks, everybody, for tuning in. We're rapidly approaching the end of the year. Geez, where did that come from? But rest assured, we have, I think we've got an ace lineup of topics between now and the end of the year. I've got a couple of provocative ones, a couple of informative ones, and some that are a mix of both. So make sure you stay tuned.
The provocative one is vaccination status for Bodies Corporate, which we're doing in 2 weeks. So that'll be really interesting.
Yeah, so it will be interesting because God knows there's not a lot of guidance around it.
Nope.
But we'll try and make some sense out of it. Absolutely. Today, though, legislation. Now, dry old topic in some respects, I guess, but yes and no. We've tried to break this up into some bite-sized chunks. Before we get into the nuts and bolts of it, as always, feel free to put up a comment and we'll try and get to as many queries as we can live. If your query is just a tad more involved, best to put your details into the link that's just about to appear in the chat, and someone will get back to you via that form. But yeah, legislation. I think it's fair to say, Frank, so I've worked in a few different kind of areas in government over the years. For me, body corporate, the people involved in bodies corporate seem to have a really keen interest in legislation and how it works. Does that mean everybody in Strata are word nerds?
It could be. It could be, but it's I don't know, actually. You're making me, yeah. So we haven't actually scripted this one, ladies and gentlemen. So you're making me think, Chris. It's sort of when you look at other bits of legislation, I suppose, if you're involved in a piece of litigation, you're not looking up the uniform civil procedure rules to see what happens. You've got your own particular dispute. But all our body corporate questions ultimately come back to what is or isn't in the legislation. And I suppose the context for this one today, you're right, can be a dry old topic, but it's a really interesting one in the context of what's going on from a legislation perspective, because we're in the middle of that Strata title working group. The next round of submissions for material closed tomorrow. So on the bits and pieces we chatted about 4 or 5 weeks ago, or whatever it is. And it's worth, I think, particularly at this time in the cycle, if you're interested enough in terms of what's going on, there might be something in this for you. And even then, how the legislation works and relates, and probably some of the FAQ that people don't know. Because for me, it's been a really interesting process. Like, as a lawyer, well, particularly you go to uni, you look at a piece of legislation, but you don't know what actually goes into it, how the thought processes that have gone into the creation of it, how, I suppose, the idea for a piece of legislation even arrived in the first place. How does that, particularly if it's brand new? So it's been a really interesting exercise for me, being part of this working group in the context of, well, this is how it happens. And I think the Director General who's running it, it's like making a sausage. It's not pretty, but at the end of it, you finish up with a product. So.
Yeah, you do, and hopefully it's tasty. Look, it can be a specialised area, and I know it can be really frustrating for people who don't really have a lot of experience to say, oh, but section 111 says this, but section blah blah says that, but what about section blah blah over here? We're going to try and pick our way through some of those challenges today and give you some tips on how to best understand. Because while Frank and I, we talk about practicalities and common sense and looking at things laterally, all of that actually comes from a start point, and the start point is legislation. So it's actually useful to have some understanding. And I guess I reckon we're well equipped to do this because we've got some complementing skills here. So you're a lawyer, Frank? That's right.
I think so. Yeah, absolutely.
So you know your way around BCCM and BUGTA legislation almost back to front these days, I would suggest. And then for me, in a past life, I actually drafted legislation.
So, but you're not a lawyer.
No.
No law degree. How do you finish up as a drafter of legislation?
Well, thank you for asking, Frank.
Without being disrespectful, of course, because not
No,
that
no,
law
no.
degrees mean you know everything.
No, it is. It can actually be very helpful to have a law degree when you're drafting legislation. But ultimately, I put it this way, Frank: legislation is about words, and more than that, it's about what the meaning of one word is in connection to the next set of words and the phrase which precedes it, and the words which follow it. So if you are the sort of person who enjoys understanding meaning of words, meaning of grammar, construction of sentences, phrases, it's probably a job for you. And in fact, here's a fun fact for you, Frank. Probably the best people that I worked with in government when I was involved in legislative drafting were not lawyers, and in fact were school teachers.
Oh.
The very best people who nailed the art of it, that was their background, teaching.
Right. That's really interesting. Because I suppose it's because they don't teach you at uni about legislative drafting. They teach you about the interpretation of legislation. But at that stage, and I suppose here's the thing, you're interpreting something that's been drafted, which by interpretation almost off its own bat indicates there's more than one way to look at it. Like there's some stuff that's black and white, but there's other bits that aren't quite complementary or don't fit. And I suppose that's back to your words bit. Use a particular defined term here and not here. Well, what does that mean? Is it supposed to be the same? Right. Is it a mistake?
It's an excellent point. You're preempting some of our exciting content, Frank. Before we get into the exciting content, question for you, Frank. What do you find particularly frustrating about legislation from a practitioner's point of view? And what do you reckon a layperson would find really difficult?
I think, like for me, I suppose, and this, you know, you want to use the phrase nanny state, I suppose. We've got legislation for more than most things. We hired a Kiwi lawyer years ago, and she came across and she couldn't believe the volume of legislation we had to deal with, because we had a particular property issue and said, why don't you do this? Well, it's prohibited by that. Why don't you do this? Well, it's prohibited by that. It's like, how much legislation do you guys have? So in New Zealand, it seems to be a bit more laissez-faire in terms of getting around things with a little bit more creativity. So I suppose there's that element. In one sense, we're over-regulated. But then the other element is, and probably the easiest example is the new modules that started this year. So there's a new provision in there that talks about an owner can submit up to 6 motions in any 12-month period, and the committee must decide them. So that 12-month period is not defined. Is it a body corporate's financial year? Is it 12 months from the time the first one went in? So if I lodge one on the 1st of June, and then I lodge another one on the 15th of August, is there concurrent 12-month periods running from the date we first lodged the first one or the second one? So I think when we both saw that, because it came into left field, it's like, well, hang on a minute, there's the gaps. Yeah. And so I sit here and say we're over-regulated, and on the other hand, then I'm almost saying give us more regulation to really define these things down. Because when I look at them practically, where that's going to get decided is someone adjudicating it over a 12-month period. And so from an industry perspective, there's a new piece of legislation that's arrived, there's this particular set of rights that are created, and none of us know for certain how they're going to be interpreted until an adjudicator looks at it and says that. And so in the meantime, we've got to say to clients, well, if you're going to run it, then here's the different ways you can look at it. We can't tell you absolutely which way it's going to go, because we can't, because the legislation's not precise enough to define that. So if you're going to ask me for a source of frustration, I suppose that would be it, not being able to give people black and white answers. And I suppose that's
that would be tough. It is tough. It is tough. Let's try and put some, I don't know, let's try and put some guidance around that. Maybe we can't answer those things black and white, but we'll give some of the periphery a go. Let's kick it off, Frank, with a reasonably common question, a fairly basic one, but an important one. What's the difference between an act and regulation?
Well, I suppose you'd call the act the primary piece of legislation, and then the regulations are subordinate to that and are made effectively pursuant to the act. So what and you see this in the BCCM Act all the time, is that the head piece of legislation includes a range of stuff that's applicable to all of the bodies corporate that are regulated by it in Queensland, other than the BUGTA ones. So, for example, Chapter 6, Commissioner's Office, that's not in any of the regulation modules. That's in the Act because every body corporate's subject to that. But then there's parts of the Act that says the regulation module may create rules around committee elections, for example. And so those things then are in the individual modules underneath that and are then subject to whatever those individual modules allow some flexibility around. And the other thing, I suppose, you see forms and regulation forms are all usually defined in the modules and that sort of thing. And the the regulations can have the fees and other details and nitty-gritty sort of stuff. So I suppose you'd say the Act's the really big thing, primary enabling document, and then the regulations underneath it, which again, we see with our regulation modules only last 10 years. Then they need to be renewed. So the Act lasts forever. The modules have a 10-year currency.
It's a really good way of putting it, Frank. Act is big picture concept stuff, regulation, detail, minutiae. Think of it that way. That might be a good way to start navigating, I reckon. Next one. What about dates in legislation, Frank? What do they mean?
Well, I suppose, like most things, there's got to be dates that things start and finish. So what you have, you're going back, I suppose, to England, where we still have, well, we've got a new governor now, don't we? Our former chief health officer. So all of our legislation in Queensland, acts at least, needs to be assented to by the Crown, which is the Queen's representative in Australia. So I suppose and as much as that's a formality, it's the way it works. So the acts will be passed in Parliament, or all legislation's passed in Parliament, and it can commence and even can be retrospective, subject to what the actual legislation itself actually says. So our modules, I think were they passed in November-ish?
Yeah, so they're 2020.
Yeah, they're passed in 2020 and commenced on the 1st of March. So we had a 5-month window where these things existed, but they weren't operative. And I suppose that was to allow everyone the chance to get their heads around it, understand it, and all the rest of it. So, and then I suppose you've got to look at how, I suppose there's interplay. If you're going to look at the COVID regulations, so we've got BCCM Act, we've got our regulation modules, then we've got other COVID regulations which came in pursuant to a specific COVID Act that defer or amend or defray some of the provisions in the modules themselves. So what you'd say, I suppose this is the law of it. You're not going to go and make all individual changes to those regulation modules, but you've got another piece of legislation out here that now says, despite the fact a body corporate might have an obligation to commence proceedings for recovery of a body corporate debt within 2 years and 2 months of its falling due, that doesn't apply now until 30 April 2022. So you've sort of got these bits and pieces lurking around underneath it. And those dates, a piece of legislation might not have all of the things that are relevant to the interpretation of it, because that is in another act and another module, another regulation.
That's right. Dates are absolutely crucial in legislation, because if a dispute or a disagreement arises, you actually have to go back to the point where that started and know what was applying, what legislation was applying at that date. That can be crucial in determining who wins and who loses in any kind of dispute, let alone a body corporate dispute.
Absolutely. And mate, I think probably one of the big things for me that's been interesting with this process is policy. And I mean, that's deep, dark bowels of government. So I suppose you've been on the other side of that desk. So how does government decide what gets addressed in these things?
What a question, Frank. To start off, government of the day makes those decisions. And when I say government, important to make the distinction, that's the elected representatives. That's not the public servants. So the public servants, such as the Commissioner, Commissioner Scott at the moment, she's not the decision maker about what goes in the Act or the regulation. Neither are the other public servants. They certainly do a lot of work around it, but at the end of the day, it will be the elected officials, the elected members of Parliament who are the decision makers. So anybody, Frank, anybody can request legislation be changed or amended. It doesn't matter who you are. You don't have to be a member of a special interest group. You can be an individual. Anybody can ask for that, but it's the government's decision about what priority they give it. So think of it this way. You might have 10 different people that you go up to in the street, and all 10 of them have a different priority about some law they want changed. Government has to decide in what order they're doing that. The order at the moment is anything COVID is first. Then you go down after that, after that, and after that. The government does that after hearing input from stakeholders. That's ideally how it is. And they might call for submissions publicly, or they might speak to people. But the process is supposed to be, you're supposed to get feedback from everybody. And as you keep talking about there, Frank, that's a process that's happening at the moment, isn't it? You've got all of these representatives together being asked for their comment on it. So while we're involved representing different bodies and different interests, we certainly aren't the decision makers, aren't we? Are we?
No. And it's been a really interesting process in terms of some of the things are relevant to some groups and not others, but it still doesn't prevent you from sort of piping up with a particular opinion in there. So, and I suppose one of the other things for me that has been interesting is, because obviously we're talking about legislation, we're talking about enforcement of legislation, because as Chris always said when he was commissioner, there's no such thing as the body corporate police. If your minutes are wrong, you don't get a knock on the door from a copper at midnight threatening to arrest you for fake minutes. It's a bit of a self-regulation thing, and so it's you've got to go to the commissioner's office. So one of the things that definitely is coming up loud and clear throughout this process is if we're talking about creating new provisions that give additional rights or changed rights that are capable of being enforced, what's the additional resource that needs to go into the mechanisms to allow those things to be enforced? So if you were going to bring in, and we haven't got here yet, bodies corporates having the ability to fine people if they don't do the right thing. That has the capacity to be abused. There's not a single, doesn't happen at the moment in strata law. So if that arrived, how many more disputes is the Commissioner's Office going to get? So sounds good in theory to do it, but where's the process and the mechanism to allow it to be adjudicated upon, and the resourcing that needs to go into that, and the education, Chris, I suppose.
Yeah, that's right.
Right.
And whether or not government thinks it's still its responsibility to educate people too, for that matter. I'm going to quickly, I'm going to jump ahead one, Frank, because I reckon this is a good one that a lot of people tuning in will want the answer to, because we hear this question quite a bit. Does the Act override the regulation module?
Yes. Well, I suppose in theory, they coexist. There shouldn't be inconsistencies between the two of them. And I suppose when I say override, that's the wrong way. I think probably the way to describe them is the regulation modules are derived or created by virtue of their ability to do so under the Act itself. But there isn't any inconsistency between them. Because the way it works, again, we've got Chapter 6 up here in the Act that talks about Commissioner's Office process. There's nothing in the regulation modules about that. We've got the Act that says the modules can come up with how committee elections are run, and then the modules deal with all of the committee elections. So there's no inconsistency. So symbiotic would probably be the way to put it, Chris, wouldn't it? They work together. So they're not one on top of each other, but there isn't any inconsistency between them. That
shouldn't be, yeah.
Yeah, I can't remember a single piece that is inconsistent, which is handy. So because they're very defined.
There might be some errors. There might be some transposition error, Frank, and that's a human error issue. But otherwise, you're quite right. We're getting a few questions there. We will get to those, everyone. Stick tight. But the next one, how does legislation get drafted and made? It's a good one, this one, isn't it?
Well, I suppose it's sort of and I suppose the last round of the modules we saw drafts. So here's some drafts. What do you think? And that, I suppose, is almost the proof checking exercise. And with the new modules, that was it was a huge exercise, obviously, because what you've got is a old module, and what the government now used to do is if you butted in a new section between 30 and 31, you might have section 30A. And then 30B and 30C. Now they renumber them all. So if you were a numbers guru with the old modules, all the section numbers, that's no good to you anymore because they've all been renumbered. So the exercise in making sure that there's consistency and the new things go in the right spot, I thought was bloody incredible. I suppose that's that word nerd bit, isn't it?
Absolutely, Frank. And if you're into that sort of thing, it's great watching it happen. My quick summary for everybody: how does legislation get made? Because it's hugely involved. But basically, what happens? There's a part of government, a real niche, and they're called the Office of Parliamentary Counsel. That's not counsel as in your local council. That's counsel as in legal counsel. They're basically the government's draft people. So it would be people like me when I was in the job. Public servants instruct them, so that you give the drafters the instructions, they produce a draft, they send it back to you, you fiddle around with it, you send it back to them, they send it back to you, back and forth, back and forth, back and forth, until finally it's settled, and then Parliamentary Council have to certify that draft. So I have been in situations, Frank, where you're there 10, 11 o'clock at night, midnight on the day before it's due in Parliament, and you're sitting there madly typing away to the draft person in the other office across the street who is producing the final version for you for Parliament tomorrow.
Right.
It is literally like that. So gets certified. It should then go to Cabinet. Cabinet approves it, gets introduced into the Parliament by the relevant minister. That's sometimes called the sponsoring. I think that's a bit of an old-fashioned term these days, but the sponsoring minister who introduces it, gives a speech about how wonderful it is. Then it gets referred off to what's called a parliamentary committee. Sometimes if it's an emergency, it doesn't get referred there. Then it comes back from the committee with their recommendations. Sometimes it'll get changed, but most of the time it won't. And I'm giving you a really abridged version here. And then it goes on a list for Parliament to debate, and it gets its term whenever government decides it's right to do it. Then it goes for debate. And it's during debate that all sides of government theoretically get their chance to make a speech about it. So let's just say the BCCM Act was being amended and a bill for that was before the Parliament. You'd have Labor, LNP, Cadders, One Nation, Greens, Independent, all have a chance to make a speech about it. And then it actually gets what's called consideration in detail, where you go through clause by clause, tick it off. The Parliament actually ticks it off. Sometimes it can be amended at that point, rarely, but sometimes, and it really shouldn't be, but sometimes it does. The vote's taken, and then, as you said before, Frank, it ultimately ends up with the governor to approve. That is how legislation gets made.
And I suppose our system is the only one in Australia that has a unicameral system of government. If we've got one house, we've got
right.
Not a lower house and upper house. We've got one house of government. So whoever's in control is in control. They're not held to account by a Senate or an upper house, which is voted in by a different way. So, it's fair to say probably the certainty that brings is what the government wants, the government gets.
Pretty much. The only difference, I suppose, is when the numbers are really tight, then they have to go through a process of negotiation and trying to do a bit of horse trading with the other parties. That's when things get really interesting. Before we maybe answer the questions, it occurs to me, Frank, we should drop down to the where do I find legislation question.
Yep.
So we're going to put up a couple of links for you there. The first one is the Queensland Government website. And then the second one is an outfit called Ostly. Frank, do you have a preference?
I've always used Ostly. And that's probably because it's got cases as well. So that's where all the Commissioner's Office decisions are. That's an incredible legal resource across the country. So I've always sort of been a bit of a, and I don't know why, I've always found myself using Ostly more than anything else. So for me, I've got a Google shortcut there on my interweb that just has all of the legislation, relevant sections and cases that I think are relevant. Well, not I think are relevant, that are relevant to what we do on a day-to-day basis. That bing, 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 there you go. But Ostly always.
Frank, we're running out of time and we haven't even gotten to half of these. We want to do some best practice and answer the questions. Before we do that, we'll go to the one that you and I were talking about just before, Frank. what happens when the legislation doesn't refer to my situation at all?
Well, then you're extrapolating. And that's the, I suppose that's where lawyers make their money in a sense, because there's definitely sometimes gaps. And I've been responsible for changing legislation 3 times now. I suppose once by, well, no, all 3 were loopholes. Easiest one though was when they froze adjustment of lot entitlements, 2011, and that was frozen as at a date. So we had a client who'd received an order to adjust their entitlements 3 days before that date, but the way the legislation would have read is because that hadn't been registered in the CMS. He was stuck with the old entitlements despite the fact he had a court order allowing it to happen. So we actually made a submission to government at that stage to say, hang on a minute, our client had just got this order, he should be allowed to progress it. And so what they did was they actually changed the legislation to allow that to get through, because, you know, and I suppose that was fair enough at the time. So, but yes, but when the legislation's silent, you're back to almost statutory interpretation about what other provisions might say. You're back to dictionary definitions sometimes for what words mean. And you're probably looking at similar style situations that might apply in different forums. So for example, assigning management rights, for some of the disputes there which don't often get ventilated, a really good parallel is landlords consenting to the assignment of leases. So it's a very, very some similarities, and there's certainly been a lot of High Court blues about that sort of stuff. So when you're looking for guidance around what should happen when the legislation is silent, that's where you go. So it doesn't mean you can't do things, but it also doesn't mean you necessarily can either.
That's a really good point, Frank. Just because it's silent doesn't mean you've got carte blanche to go ahead and do what you want. The other tip there is a couple of mysterious things called explanatory notes and second reading speeches, and definitely the courts look at those if something is unexplained in legislation, so you can give that a go as well. You might have to hold that particular discussion over for part 2 of this. Let's try a couple of the questions, Frank. Mandy, it's more a comment than a question. Thanks though, Mandy. Most difficult issue for our building is getting BCCM advice, the advising committee. They're working outside the legislation, but they choose to ignore. Probably what I'd say there, Mandy, is that that's pretty risky for a committee to be given some reasonably clear-cut information and choosing to ignore it, because they could potentially be liable for that. Frank? And
that's sort of consistent with what Julia's question is down below about, I suppose, to me, that's about sort of staging payments so to avoid void or keep it below spending limits. But the legislation on that one is relatively clear that a project is something that different component parts form part of, which then goes over. So, you know, and you're back to what happens when a committee or a lot owner or a resident manager or a lawyer, whatever, I suppose in a strata context, isn't doing what they should be doing. That's what the Commissioner's Office is for. That's the unfortunate reality of it. The legislation says people must do things. If they don't, then they can be accountable in the sense of the Commissioner's Office if you go through the process, as much as that doesn't help you today with your particular issue. But that's what they're there for.
That's right. Sandra, what part of the Act or regs instruct a committee to follow process rather than a committee minority insisting on putting all issues to voting by all owners when previously managed by a whole committee? It's a good question, Sandra.
That is an interesting one.
Yeah. So what you're talking about there effectively is the difference, if I've understood that right, between committee decision-making and general meeting decision-making. So a committee can't decide everything. They're quite restricted in the sorts of things they can decide upon. It seems like you're talking about a scenario in which the committee could make a decision, but are instead referring it to a general meeting. To me, and I'll see what you think, Frank, that suggests a committee that's a little lacking in confidence, lacking assurance, and lacking guidance, gun shy. Yep.
No, and that's the thing. Like it's the legislation says the committee can make a decision, not that it must. So I absolutely, and I mean, we've absolutely given this advice before to clients on committees that are really dealing with what are hot topic issues in bodies corporate, is you don't have to make the decision. You can put it up to owners in general meeting. And if you're going to avoid criticism, give everyone their say, it's one you can. So they don't have to, But if you're trying to avoid and really engage with owners and let everyone be involved in the decision-making process, then here we go.
That's a good point, Frank. Peter, nice to speak with you again. Peter, have you found any areas where you feel the Act and regulations conflict? I think we kind of touched upon that before, didn't we? I think we couldn't think of anything off the top of our head. I think there might be some areas where the regulation modules are not consistent, but in some cases that's quite deliberate anyway. But there is such a thing as error in drafting. Absolutely, it happens. I go back to what I've mentioned before, people working until midnight, having worked there for the last 14 hours, they're going to miss something. It happens all the time. And that's when you get very angry ministers' offices calling you saying, what happened there? Well, this is what happened.
It's my 15th cup of coffee and the brain stopped working.
Yeah, that's probably a story for another day. Best practice, really quickly, because we well and truly getting to the end today. So what's our best practice here? Legislation's tricky and complex, isn't it, Frank?
It is. And look, it's even, and leaving BUGTA aside, which I just don't give immediate answers to because that place is terrifying, the gaps in that legislation. But no, it is. And it's even now, I still, I mean, it's all I do, which is fine. I suppose all you do too, mate. So you should know a lot about it. But you still want to second guess yourself sometimes because there's those elements that when you're moving 1,000,000 miles an hour, you sometimes have to double check. So even those COVID regulations, they've changed borrowing limits. They've removed the obligation to pursue, given ability to refund sinking fund levies in certain circumstances and those sort of things. There's always that little extra bit. So you can never take it for granted. I think it's probably that it should be simple. They're trying to come up with self-governance, but the nanny state, use that phrase again, there's a lot of words there and there's a lot of places, and sometimes they're not all in the same places.
So don't make assumptions about it.
No.
Yeah.
Yep.
That's the surest way possible to run into trouble. I reckon, Frank, we've got a part 2 up our sleeve on this one. I don't think we've got the half of the things we wanted to cover today.
No.
So we might give a part 2 on that. Very quickly, Gleno, I know you're a regular. Thank you. Does repeated valid adjudication applications attract a vexatious ruling? In short, no.
Yeah, you trigger Chris with that one, mate.
Yep.
He believes there should be vexatious applicants, but there isn't in the Commissioner's office.
No.
Costs can be awarded against people, but you can't stop them making applications.
If I have my way, there might be, but that's a discussion for another day. Gosh, thank you, everybody, for engaging in really good engagement on a bit of an esoteric topic. So well done. Thanks and I think more than anything, thanks very much for making the effort to tune in. Next week, Frank, we're taking it to the bank.
Yes, financial management. It's an interesting one, that one. There's a range of things that I suppose people do well, but not well, and not at all, which will be interesting.
So yeah, bank accounts and related next week. Stay tuned for that one. But for now, Frank, thank you.
Thank you, mate. Thank you, everyone.
Thanks, everyone. Do appreciate it. See you next week.
See you guys. Bye.
Bye-bye.